I'm assuming Mary Miller, like, okay this item. I read some of the emails from the public records request, and all 3 trustees said, I have evidence that there's been an open meeting law violation, and I'd like to place this on the agenda. So what's that open meeting law violation?
I know for a fact that 4 trustees communicated on this agenda item.
On what agenda item?
I don't know if this is the avenue, because from what I heard on the crowd, I have to submit an ethics violation, which I'll be doing this afternoon, well, this morning, almost this morning. So I'll be doing that. But I know there's been unethical communications. I know that folks are not communicating transparently. And at the end of the day, there's a reason why all these text messages have disappeared. There are emails that, again, don't show up. And that's because there are unethical communications happening behind closed doors. It's also the reason why I've submitted my own personal phone for public requests, for public record requests. Because
Okay.
I want it all out there in the public.
The correct procedure would be, if that's true, that you file an open meeting law complaint with the Attorney General, and then you would have asked him to invalidate the vote that we took.
Well, this is the reason. I know it happened, and I talked to Mary Miller, and she said this would correct an open meeting law violation. If I am also correct, my abstention was not legal. I did state a fact. I couldn't in good conscience continue with a process that I knew was flawed because of these violations, because of these unethical communications that happen very regularly on this board.
I think that you should probably disclose what those are, and then Mary Ann Miller can determine whether or not we can move forward with this item.
Mary Ann?
If there wasn't an open meeting law violation, we shouldn't be discussing this right now.
Trustee Ford, for just a moment, please let me break in. I want to get a clarification. Where we're going right now in this direction, Ms. Miller, should that be happening under this item or 5.10? Or both?
Regardless of whether or not there was an open meeting violation, somebody that voted in the prevailing side can bring back a motion for reconsideration.
Okay.
So if you want to get to the merits or not, you should vote on this item up or down.
All right, so it was, I think that Trustee Cepeda just made a statement where she said that you said it was okay to go ahead and bring this up. And I know that in conversations with you, myself, you said that you had no knowledge of a pending OML violation from the Attorney General or nothing formal submitted to you. Is that correct?
That's correct.
Okay. So is there any truth to the fact of what was stated is that that would have needed to have been brought back up by the subsequent meeting, which would have been November 14th?
I'm not following.
I believe that it was brought up as far as that this would have had to have been brought up as far as rescinding by the subsequent meeting. So in other words, there seems to be some confusion about whether, and Trustee Cepeda was stating, I think she said ethics violation, but I think what was said in the statement and what she originally said was an open meeting law violation. I think that's what Trustee Ford is referring to. So those are not the same thing, correct?
Well, there could be some carryover yet.
But I mean, an ethics violation is usually submitted to the Ethics Commission, correct?
Usually.
Could I get a little bit more clarification on that?
I don't understand your question. Procedurally, the matter is correctly before you. If Trustee Cepeda felt that her previous vote was tainted by a violation of either ethics or open meeting law, she was within her rights to bring this matter back for reconsideration.
I see. Thank you. That helps a lot. And it would not have had to have been submitted as an open meeting law violation.
That's correct.
Okay. That's what I was asking. I'm sorry that I did
I'm
not
sorry, I didn't understand.
word that correctly. So I'm going to go back to the queue.
I
Yes,
wasn't finished.
I was going back to you.
Okay. So I did write a little something first because I was very confused by this item with again, having no reference material and not very much context in the description. So when I saw the item, I expected something to come to us. When I saw that all trustees said, I have evidence of an open meeting law violation, therefore it merits putting this item on the agenda to possibly rescind the vote, I thought, okay, I should be getting something in my email, or something should be uploaded to reference material. Neither one was. I also had concerns about open meeting law violations happening regarding Jara's employment. But my concerns are from the May 13th meeting when his contract was extended. So I'd like the record to reflect that on June 29th, 2021, I filed a complaint with the Attorney General, and it's currently in the review process. I'm going to submit a copy of it for the record. If there's no evidence that was stated that this item, that there was an open meeting law violation, then it should be dismissed. And if we're going to continue forward with the conversation about potential open meeting law violations, then I'd like it to include mine. And I am prepared to share an excerpt of mine. Dear Attorney General, I believe the matter of this complaint is urgent since it involves taxpayer dollars and the contract in question is scheduled to terminate on June 30th, 2021. I ask that you prioritize. My name is Danielle Ford. I'm an elected trustee of the Clark County School District Board of Trustees, District F. I'm filing an open meeting law complaint in relation to the CCSD school board meeting held on May 13th, 2021. I believe that there was an open meeting law violation during that meeting. The issue that was being discussed by the board at that time was whether to extend Superintendent Jara's employment agreement or to allow the contract to expire on its original termination date of June 30th, 2021. I shared some facts with the Attorney General. Again, I'm going to get a copy to everybody. But in January 2021, at a confidential attorney-client meeting, the board was notified that Dr. Jara's interpretation that his contract, which included a clear termination date of June 30th, 2021, had been extended by default, and another 2 years had been added to the term of the employment. Board Attorney Mary Ann Miller advised the Board of Trustees that if Dr. Jara's interpretation was correct, and we didn't consider an extension, we could be liable for 2 years of his salary, plus all litigation costs, possibly causing the district millions of dollars at the expense of the taxpayer. On March 4th, 2021, at a confidential attorney-client meeting, Board Attorney Mary Ann Miller encouraged the trustees to send an offer to explore Dr. Jara's intention. Attorney Miller advised that if Dr. Jara accepted, the offer by him would not be binding and that she would come back to the trustees for further direction. She advised that trustees would always reserve the right to change our minds or go in a different direction. On April 19th, 2021, a confidential attorney-client meeting was called on short notice. During that time, Attorney Miller unexpectedly pulled the board with a series of yes or no questions. Although Attorney Miller took the lead in polling, several trustees questioned the process and did not agree that it was appropriate. At the conclusion of the meeting, April 20th, 2021, Attorney Miller sent out an offer to settle the employment contract dispute to Dr. Jara. Prior to the offer going out on April 19th, 2021, Dr. Jara announced at a dinner with principals from the Administrators Union, Stephen Augsburger can confirm, that his contract had been extended. Neither Dr. Jara nor his lawyers had been contacted by Attorney Miller at that time. A trustee must have broken confidentiality as well as open meeting laws and shared with Dr. Jara. This was not what the trustees had authorized, which was to explore possible solutions. On April 20th, 2021, the board secretary sent trustees an email on behalf of Board Attorney Mary Ann Miller stating that Superintendent Jara had accepted the offer to extend his contract with no other details. On April 26th, 2021, our secretary emailed us, trustees, attached is a draft amendment to Dr. Jara's employment agreement. The amendment will be placed on the May 13th, 2021 meeting agenda for board action. The document had not been seen by the board and included language that was never discussed or agreed upon, including, whereas the board has determined that it is in the best interest of the Clark County School District to extend the term of employment of Dr. Jara. I'm almost done. The last time trustees met in closed session to discuss Dr. Jara's employment was April 19th, 2021. Notice of his acceptance was never brought back to the board. No further discussion with the board attorney was had, as was told to us would happen during the March 4th, 2021 closed session. Trustees did not have a chance to weigh in on the resolution or amendment to Dr. Jara's employment agreement or asked what meeting it should be placed on. It was automatically added and published publicly with the agenda for the upcoming May 13th regular board meeting. On May 13th, 2021, A regular board meeting was held, and item 5.01, superintendent contract extension. Open meeting law violation was mentioned by trustee Linda Cavazos, trustee Lisa Guzman, and myself. Other trustees stated that the Board of Trustees had previously agreed to vote to extend Dr. Jara's contract during closed sessions. Some trustees chose to not engage in discussion about open meeting law possible violations and pushed the vote forward. Excerpts of transcripts attached. My interest as a public official. I believe that my rights as an elected trustee to be able to exercise my discretion and my vote on behalf of my constituents as to whether Dr. Jara is suited to serve the needs of our children were denied. In addition, Attorney Miller expressly advised the board that her actions would not deny any trustee the ability to exercise her judgment as to whether to extend the employment contract for Dr. Jara in a public meeting. She misled the trustees as she independently negotiated a settlement that Dr. Jara accepted, which was not voted on by trustees in closed session or regular meeting. Finally, as an elected official, I have developed a brand for integrity and truth-telling with my constituents. Attorney Miller's actions give the appearance that I am disingenuous, since her actions undercut my ability as a trustee to discuss at an open meeting the merits of extending Dr. Jara's employment contract. I am requesting that the Attorney General invalidate item 5.01, superintendent contract extension during the May 13th, 2021 CCSD Board of Trustees meeting because of open meeting law violations. I have excerpts of transcripts from the closed sessions referenced. I ask that this matter be given priority as Dr. Jara's original employment agreement had a termination date of June 30th, 2021. Danielle Ford, trustee, CCSD Board of Trustees. That is what you do when there's an open meeting law issue.